Thank you, everyone, for coming today to the League for Civil Discourse Fall Symposium of Ideas. My name is Ajay Proth, and I'm the head of the League for Civil Discourse. And today, with our student panel, I'm very lucky, by the way, to be joined by my leadership team of Tui Bullock, Reza Harian, and Quinn Song, who have been so helpful in this process. And before we get started, I want to thank Dr. Randolph for all of his help and guidance as our faculty sponsor. So we can all give one more round of applause, Dr. Randolph. And and I also, so thank you, Dr. Randolph. And I also wanted to thank Ms. Sterling as well for helping us plan throughout this process. And so a huge thank you to them. Also a huge thank you to everyone for being here today. This Fall Symposium of Ideas reflects our goals of the student group, which aims to spark civil and healthy dialogue, debate, and discourse on pressing topics that affect our world and our generation today. And so today we will be asking questions that we as a group have spoken about before, and we'll open the floor later for any additional questions we have. And without further ado, we'll get right into the speaker today in the symposium. And today we are very fortunate to have Professor Vikram Khanna speak with us today. And Professor Khanna is the William W. Cook Professor of Law at the University of Michigan Law School and the faculty co-director of the Joint Center for Global Corporate and Financial Law and Policy. He has been a visiting professor of law at Harvard Law School, a senior research fellow at Columbia Law School and Yale Law School, and a visiting scholar at Stanford Law School. He is an expert on legal and professional responsibility, among many other things, and has given talks throughout the world, including Greece, Turkey, China, India, Brazil, and other countries. He is the founding and current editor of White Collar Crime e-Journal, and he has also testified before the United States House of Representatives and the United States Senate. His papers have been published extensively in law journals such as the Harvard Law Review, Michigan Law Review, Supreme Court Economic Review, Georgetown Law Journal, and many others. And Professor Khanna currently teaches courses at Michigan Law on subjects including law and ethics and white collar crime. Today, we are incredibly honored to have an extremely renowned professor of law speaking with us today. And so please put your hands together for Professor Vikram Khanna.
Thank you. Thank you, Ajay, for a very, very generous introduction. It makes me sound much more glorious than I am, but thank you for that. And when I spoke to Ajay about this session, he mentioned that people might have questions about the recent election and about how and when people with various allegations and charges against them could run for office, what sorts of issues they may face when they're in office and so forth and so on. And I'm happy to discuss those, of course. But I'm also encourage all of you to ask your questions as we go through. You don't need to wait for me to finish. I'm used to being interrupted. My day job is being a law professor, so I get asked lots of questions all the time. And I've gotten accustomed to ducking and bobbing effectively, hopefully. So I'll look forward to whatever you may ask of me. So I thought I'd begin with just a couple of quick words that, I get asked this question all the time, especially before this election, but even otherwise, which is how is it that people can run for president or other elected office while they have pending criminal charges or criminal convictions against them? And I thought I'd begin with trying to take us back a little bit to understand why the US Constitution does not actually limit the ability of someone who's been convicted of a crime or a felony from running for office. And the very simple reason for it typically, and this is true in many countries, is that there's often a concern that the state or the government may use the criminal process as a political tool against its political enemies. Now, in the US, we haven't really worried about that for a very, very long time because we generally believe the criminal justice process runs through a professional part of the government, the prosecutorial office, and so forth. But traditionally speaking, in most countries, when they first obtain democracy, they're usually leaving some kind of a monarchy or some other kind of state-run system where the criminal justice process was usually used or often used against the political enemies of the current rulers. So, for example, if we had looked at the founding fathers and asked how many of them had criminal charges pending against them at the time of the US Revolution, you would have found that many of them had. And the reason for that was because the British considered many people who were leading the US Revolution to basically be versions of either terrorists or people engaged in something called sedition, which used to be a crime in many parts of the world, including the US way back when. And so there was a general sense that when the US gained independence, that a lot of the leaders had been sort of running at some level from authorities. And I think they felt that it seemed a large restriction on future generations to say that if you had had a criminal conviction or a felony on your record, that you could not be elected to higher office. Because many leaders had actually been the subject of criminal prosecutions in the US and indeed even in the UK and in Western Europe and even in Asia. Most people don't realize this, but Mahatma Gandhi, usually thought of as an apostle for peace, was in jail for about 9 months on essentially sedition charges in India. So when you look sort of around the world, there's been something of, I think, a historical reluctance to restrict who can run for office based on whether or not they faced criminal charges. Now, having said that, obviously, there would be a natural concern that you don't want criminals running your government either. So the way they tend to balance this is that they don't restrict who can run, but they make it possible to impeach you should you engage in crimes or other kinds of wrongs. In the US, the Constitution uses the language high crimes and misdemeanors. You've probably become familiar with that because in the last 20 years, we've had, I think, no less than three impeachment trials in the US presidency. In fact, that understates it because many sitting judges can be removed from their office if they're impeached. And the standard is essentially the same, high crimes and misdemeanors. So we don't typically prohibit people from running for office because of a criminal conviction, both because we think the criminal justice system could be misused, and indeed historical evidence suggests it has been misused, but also because some crimes might have been engaged in when you were very young, and perhaps when you didn't realize the long-term implications of them. So we don't normally bar people from running based on crimes, at least not the average crime. And then if we're worried about people doing things that might be problematic, there's always the impeachment power. Not used as frequently as one might think, but that may simply be because you don't usually have, people who have convictions who are getting into higher office because oftentimes once the general public knows that someone has been convicted of something, they may be a little less inclined to vote for them. Not always. Freedom fighters often have criminal convictions and they're often lauded for their bravery in fighting that. And so you often see that people with convictions are not barred from running, but they're often permitted to run, subject to the possibility of being impeached later. Of course, there's a separate issue about someone who hasn't got any convictions right now, but allegedly might engage in criminal behavior while in office. That's a different kettle of fish in some ways, because the issue there is not that someone has done something in the past and is trying to run for office. It is they might be abusing the power of their current office by engaging in various crimes or other bad behavior. And typically, what you see here is the impeachment power being used as a way to block people from using the state to benefit themselves, that is, engaging in crimes. Again, though, you'll notice very rarely are sitting presidents or sitting heads of state charged with crimes or convicted of crimes. And the reason for that, again, is a political one, which is largely speaking, most countries will not pursue criminal cases against a head of state while they're a sitting head of state, on the grounds that essentially to do that would mean that you're trying to overturn the election in another country. And that would be perhaps not the best incentives to give nations. You could imagine people simply convicting the leaders of other countries they dislike or the policies they dislike. And as a general matter, most international law and principles of international law will limit your ability to criminally go after someone who's a sitting head of state. There are some exceptions. If you're, of course, engaged in genocide or certain other very large international crimes, then other states may treat you as a rogue, maybe a rogue leader, and then bring criminal cases against you. The biggest problem they're going to face is if you're a sitting head of state, there's no easy way to go into your country and extract you from there and subject you to a criminal prosecution in your country. So, as an example, it is highly unlikely that the US would send a commando team or any other sort of army force into a foreign nation in the hopes of capturing their leader and bringing them to justice in American courts. It does happen, but it's pretty rare. And so you don't usually see criminal cases against pending heads of state, against current heads of state. Sometimes when people step down from being a head of state, you'll then see criminal cases being brought against that person in their individual capacity. And it's generally thought that those don't involve the same kinds of political considerations as might be present when you're going after a sitting head of state. Um, and then, of course, we'll see how you know that sort of develops over the next few years as various wars and other things continue. The other one that comes up a lot is what powers does a sitting president have to do things within a particular country at a particular point in time? The answer to that varies tremendously with what is the question that you're asking about what they can do. Can presidents overturn laws? No. Can they decide how to enforce the law? Yes. Can they overturn judicial rulings? No, not by themselves. So there are limits on what they can do. Can they change how the federal government works? Yes and no. Some things require them to do it on their own. Some require them to work through Congress or through other agencies. But generally speaking, if you're thinking about what are the limits and constraints on someone who can run for a head of state, there are very few of them in the US. In fact, the two that are mentioned in the Constitution are simply that you be above the age of 35 and that you be a natural born US citizen. That's essentially it. There are no other requirements to run for office. And in fact, it's not entirely clear why they have an age limit on who can run for office. Not every country does. Well, every country has at least 18, which perhaps is a little unfortunate, but nonetheless, the idea is that typically you have to be an adult and besides that, maybe be born a citizen, although that's not even true in some countries. You can be a naturalized citizen and run too, just not in the US. Anyway, I thought with that the short sort of overview, I would open the floor to whatever questions or thoughts you might all have. I'm happy to speak more broadly, but my understanding was that people were probably very interested in the election and issues are sort of arising from it.
Yeah, thank you so much, Professor Khanna. Super helpful to kind of contextualize our current situation, and I think and we also want to open the floor to anyone if with just the raise of a hand and an introduction of what your name is and your grade before you ask a question. But one of the questions that many of us were thinking about is that many people think of the federal legal system as just the Supreme Court necessarily per se. But could you give us some insight into what the federal legal system is comprised of and what it means?
Sure. So the federal for the federal legal system refers to two different things at least. The first is the federal lawmaking authorities, which would be Congress, and then secondarily the agencies like the IRS, the Securities and Exchange Commission, and various other government agencies. If what you mean is a federal judicial system, then that is actually a series of courts. The highest court in that is, of course, the Supreme Court of the United States. But below that are 11 what are called courts of appeal. The word they use for them is the circuit courts because they divided the US into 11 circuits way back when. And so you have 11 circuit courts of appeal. And then below them, you have a series of federal district courts. And usually, when you bring a federal case, you're going to face a series of questions. The first is whether you're alleging a violation of federal law. So in the US, we have two legal structures running at the same time. We have state laws that are enacted by individual states, like Michigan has various laws. And then, of course, you have laws enacted by the federal government, that is done in Washington. The first question in a federal case is going to be whether there's a federal law that has been allegedly violated. And then typically on top of that, there are requirements and restrictions before you can access the federal courts. So you can't normally access the federal courts for, someone not paying you $10. You need to have a substantial amount that you're seeking before the federal courts will be activated. You need to show that violation of federal law. And then whichever court you go to, you can't just shop whichever court you want to go to most of the time. You have to actually say that there's a reason why that court should be handling your dispute. The first court you're going to deal with is usually the federal district court. There's a series of federal district courts here in Southeast Michigan. In fact, there's one in downtown Ann Arbor. Most people don't realize that. There's a federal district court. If you know where the post office is on Liberty, uh, that's uh, that's out does double duty as a federal courthouse too. And there, of course, you'll have people that are charged with violations of federal law, including federal criminal law. One of the largest areas of federal criminal law is white collar crime, which is one of the areas I work in mainly. Once you go through the federal district court, you can appeal to the circuit courts. And then if you're unhappy with the result there, you can appeal to the Supreme Court. The Supreme Court of the United States has discretion about whether or not it will hear your case. So there are usually like 2,000 to 2,500 cases that want to be heard by the US Supreme Court each year, but only about 90 to 95 actually get heard. And that's because the Supreme Court decides it doesn't need to make a decision in the other cases because it doesn't raise an issue or issues that are sufficiently significant that the Supreme Court needs to address it, or the issues are not sufficiently developed so that the Supreme Court could give a reasoned opinion. That's basically the federal judiciary. Federal judges are appointed by the nomination of the US president and then by confirmation by the US Senate. So when in the news, you hear all the time that maybe someday a Supreme Court judge will retire. If they do, then the US president, whoever the sitting president is, gets to nominate someone to fill their seat, and then it goes through an approval process in the US Senate. President-elect and former President Trump nominated and had 3 Supreme Court justices appointed during his first term. President Biden had, I believe, 1 justice appointed during his term, and so forth and so on. There are 9 justices of the US Supreme Court. They sit together and make decisions. And if I've been to the Supreme Court several times, and it's interesting to see the hearings. They will pepper the attorneys with questions. When you go in to argue a matter in front of the Supreme Court, they will be well prepared and ready to fire away on questions, and so you should be ready to answer them. And the judges have very different perspectives at times, so you could get questions from any direction. The other side of federal lawmaking is Congress and to a certain extent the agencies. But congressional lawmaking is, as they describe, a sausage making process, which is unpleasant to behold at times. So.
So much.
Yep. Sorry, this might not be the best question, but I have a question about that.
Could you give an introduction of yourself?
Oh, sorry. My name is Ashu Bharat. I'm a 9th grader.
Nice to meet you.
Oh, nice to meet you too. So having as we've seen in the current the election that has just happened, the Republican
Yes.
Party has control over the legislative and executive branches, and they
Yes.
also Trump has also chosen 3 of the justices. How do you think that impacts current lawmaking that that they could I don't know how do you think that impacts laws that they could put into place or policies?
Sure. So, I mean, I think that's a good question, by the way. I think that there are several different ways to think about this, right? At a baseline level, if President-elect Trump had won the presidency, but both houses of Congress had been Democratic, then obviously that would require him to compromise with Congress to get certain things done as legislation, because they may have different perspectives on what they think is the appropriate law or rule than he might. Now, with all the houses of Congress being Republican and the presidency being in the hands of President-elect Trump, that would mean that the degree to which you would need to compromise with Congress to enact law will probably be a little less because since they're in the same party and many of them are working closely with him, the chances are that their perspectives will be a bit more closely aligned. And so one would not expect as much need for compromise as you would if the Houses of Parliament, the Houses of Congress were in a different party's control. So that's sort of the first, sort of the most general point. Having said that, the US government, federal government, is set up with a lot of checks and balances. So yes, although Congress may not provide as tight of a balance, the Senate has certain rules in it that actually slow down decision making and approval of decisions. So for example, generally speaking, you only need 51 out of 100 senators to vote in favor of something for it to be passed. Except they can only vote on something once debate in the Senate has stopped. It's happened many times in US history that senators have refused to allow the debate to stop. So there would be no opportunity for a vote. That process of not ending the debate is called a filibuster. Many of you have probably heard of this in different contexts. So a filibuster means that you cannot stop a senator from speaking on a matter unless you get 60 other senators to stop them. So a senator who's from a minority party or is aggrieved by the process can basically keep talking in the Senate endlessly in order to prevent a vote being called on a matter, unless 60 other senators say, okay, we need to stop the debate. That means that for important pieces of legislation, even being in the minority in the Senate can be effective in slowing down or blocking certain things from happening. Now, that the filibuster is not available for everything. Over time, the Senate rules have been amended to allow the filibuster in some cases and not in others. If you get a chance, you can always sort of look back over time, and you'll see that there are senators who go on talking for like 45 hours, 72 hours. They bring in, beds and mattresses to the Senate. They bring in lots of coffee. They bring in a lot of really bad baked goods. I'm not sure why they do that. You were allowed 10-minute bathroom breaks, and I think one 15-minute shower break. If you've ever been to the U.S. Senate or the Capitol Hill, you'll know that there are actually private bathrooms there. There's a private gym there, a members' gym as they call it. So there are ways to slow down decision making and legislation, but when you have all the three branches of government that are sort of more closely affiliated with each other, then the ability to slow down the decision making becomes less than if they were divided in a different way. What does that mean? I mean, what it suggests to me is that the first 100 days of President Trump's upcoming administration are likely to be very active because the next set of elections is in 2 years. And presumably, whatever are the things they think they need all the arms of government for, they're going to try to push through now. I'm told by friends of mine in DC that we should expect a lot of executive orders within the first week after the inauguration. Executive orders are where the president directs law enforcement, federal law enforcement, to do or not to do certain things. He can ask them to police certain areas of law more intensely or to police certain areas of law less intensely. And there are ways to constrain that, but the people who work in the White House have over the years figured out ways to write executive orders that don't violate the Constitution as much as they might have in the past. I mean, President Biden issued a lot of executive orders too. I suspect President-elect Trump will issue a lot of executive orders as well, especially the first 100 days. You may see some legislation being put forward to change laws in various areas. And what laws he suggests and so forth may depend greatly on his conversations with people in Congress to assess how much opposition they're likely to face and how much will be the need for compromise.
Thank you. Hi, Professor Khanna.
Hey
I'm
there.
Jay Bullock, a sophomore here, one of Ajay's partners in leadership for this league. And kind of piggybacking off of Ashu's question, but to like a more like general scale, what are your reactions to this past election and its consequences on the legal landscape?
So it'll be really a very good question. It'll be a really interesting series of things because um, the cases that are pending against President-elect Trump, I suspect, will not be allowed to go forward while he's the sitting president. They'll be either held in abeyance or some may just get dismissed. Some may continue. The civil cases may actually continue, but I suspect they'll get appealed and they'll drag on for a little bit. That's at the individual level with cases related to him. I think matters related to what are likely legislative initiatives and likely impacts on how things work. A little hard to predict, although it's worth noting that President-elect Trump in his last term in office followed through on a lot of the things he had said he would do in his stump speeches. So there's a good shot that he will follow through on at least some of them. Uh, I imagine there will be some kind of effort on immigration. I'm not quite sure if it will be um, enforcement oriented. That is, will he ask the enforcement arms to do something, or will it be more legislative? That is changing the laws. Might be both. He's talked about reducing family-based immigration, tightening up illegal immigration, and increasing legal immigration. Those are all three different things, but often related to each other. It would not be surprising to see that various limits on industries or behaviors that affect climate change may change. That seems quite likely. I mean, the suggestion is we should anticipate more fracking going forward. Uh, there's also discussion of what might be some of the health initiatives that are coming out. He suggested Robert Kennedy Jr. as his Health and Human Services Secretary. Mr. Kennedy has, or soon to be Secretary Kennedy, has often suggested that we use vaccines too much. So perhaps there may be alternatives that are suggested for certain things. You can imagine all kinds of things. Right now, there's quite a lot of things that are up for presidential and federal decision making. The banking sector is likely to receive some additional regulation or re-regulation. I think that's going to be true for the environmental side. He's talked a lot about wanting to encourage crypto, so you might see more crypto legislation. And then, of course, he's appointed Elon Musk and Vivek Ramaswamy. Well, he hasn't actually appointed them. He's named them to lead something called the Department of Government Efficiency. Those of you who follow acronyms might notice that the acronym for that is DOGE, as in Doge. That's Elon Musk's crypto coin, Dogecoin, or the one he supports at least. Department of Government Efficiency. There is not actually a Department of Government Efficiency. The president cannot create a department of the federal government by himself. He will need to pass legislation to do that. Creating government departments is not easy, especially if the mandate of the government agency is to reduce the power of other government agencies. That's, but he can certainly create or get advice from people, whoever he so chooses, and then decide to put forward either legislation or change regulation within entities to streamline it. So when I teach white collar crime, I usually, which I'm doing this semester, I usually ask students, how many things do you think a business or an executive can do that might lead to criminal prosecution? And usually most people start with 100, they think murder, theft, 4,000. And I tell them, no, it's higher than that. So then usually there's some cavalier students will say 10,000. I'm like, yes, you keep going higher. And some will say 20,000. And I'll say, keep going higher. And then now they get a little nervous because 20,000 is kind of the upper range of what most people can conceptualize. So then I say, no, it's higher. They're like, okay, 50. I'm like, no, it's higher. Now at this point, they're quite confused. I'm like, yeah, it's higher. They're like, how much? I said, give me a number. They said 100,000. Higher than that too. It turns out you after 10 more minutes of doing this, you end up at around a little north of 500,000. that is approximately the number of federal regulatory offenses that can turn criminal. Uh, that suggests that there's quite a lot of rules, right? Now, that's not to say that there's too many or too little, it's just that's a lot. So if you were to have the president go in and say, you know what, I think we should reduce rules number 1,000 to 5,000 in the in the Environmental Protection Agency, some of those he can do on his own, some he has to get passed through Congress, but you could certainly imagine them trimming back a lot of regulation. How much is a different story. I think there are some areas where the president will find much greater headwinds in trying to do something, and others where it'll be easier. But yeah, that seems to be the general direction.
Hi, my name is Quinn. I'm a ninth grader. I wanted to talk a little bit more about you
Hi.
teaching your law students. So I wanted to ask, what do you find most rewarding about teaching law students, and what advice do you give them as they enter the legal profession?
Sure. So the part I probably find the most fun is actually when students ask me questions and we have discussions in class, because that's you know not to put too fine a point on it. I've been teaching for some years, so the material itself is relatively familiar to me. What's not familiar and what's more interesting and exciting is the questions people have and the thoughts they have, and what motivates them to sort of think about asking that question, or what motivates their point of view. To me, that's the most interesting part. Um, I enjoyed, the research and the writing, which I do as a law professor and things like that. But the most fun of teaching is actually the questions. I generally tell my students that my class runs on what's called a gentle Socratic. That is, we do question and answer, but it's gentle because I administer Novocaine before we pull out the teeth. So that's usually the way we discuss it. That's meant to be a little bit of a joke. If you've ever seen The Paper Chase, people are terrified of how law professors run classes. We don't really do that anymore. That's from 1971 or something, which is a very long time ago. It's not quite Legally Blonde either, but it's kind of somewhere in the middle. But I'd say that's probably the most fun. Advice for people who are entering the legal profession. I would remind them that making a legal argument is not the same thing as arguing. What we see on TV is arguing and political debate. That's not what goes on in court, at least not often. In court, you're making arguments based on existing law and trying to show how your particular client's considerations merit favorable treatment under that law or under a different interpretation of the law than the one that's currently there in the courts. It's more constrained than the types of political debates you might see on TV, or for that matter, what you see on TV shows related to law. The vast majority of TV shows related to law are not helpful, let's put it that way, in terms of indicating what lawyers do. The most lawyers do not argue like that in court. I'd say the most relatively useful description of how lawyers argue is what you might see on Law and Order, but even that's a little overdramatic. The other thing I tell people entering the legal profession is the beauty of law is that it changes with the situation and with time. So if you think a set of laws right now are not the kinds that you would favor, the beauty of the legal system is that there are ways to amend it and change it. Even the US Constitution has been amended many times. I think more than 20, in fact, which is saying a lot. So regardless of whether you approve or disapprove of a particular set of laws, things tend to change over time, and people tend to be very responsive to new developments, new technology. The world that lawyers are entering is different than the world that we entered when we graduated, and will be different than the world people enter in a decade. Technology will be a much bigger part of law practice when people of your generation enter. When I entered law, the technology we had was email had just become a thing. We used to send emails on something called the Pine Network, which to you now will look like, good Lord, the Stone Ages probably. But nowadays lawyers go in and they're beginning to think about matters related to AI, large language learning models and things like that. By the time you get there, I anticipate there being various kinds of technological interventions, broader understandings of things. One of the beauties of law is that it both responds to and reacts to pretty much everything major happening in society, and then it also can impact things in a major way that are happening in society. So if you want to do something to impact how people live and how they do things, law is a fantastic profession to be in.
Hi, Dr. Khanna. I'm a sophomore like Tui. My name's Reza. I have a question about our American legal system and stability of our system. So both political parties seem to accuse each other of weaponizing
Mhm.
the justice system. And how do you think that affects the stability of our American legal system in the polarizing times of today?
So it's very hard because not only are the political leaders engaging in rhetoric that is polarizing, so is much of the media. And as a result, the net effect of that is the general population develops shall we say, a more jaundiced view of how the legal system operates. The trouble is the legal system is actually relatively slow moving. Now you might say, well, why is it so slow moving? It doesn't want to get carried away one way or the other, typically. The general sense of the legal system is humans and human society um, tend to have difficulty dealing with large scale changes, and they tend to prefer incremental change because incremental change requires you to adjust your life a lot less than radical change does. Also, the risk of getting things wrong is probably larger in radical change than in incremental change. So typically the legal system moves on notions of precedent, that you need to do things that are consistent with how case law has been in the past, that there are principles and doctrines that are sort of that carry weight beyond the year in which they were put forward, right? So that dynamic means that the legal system does not respond as quickly to the pushes that you see on the political side, which is good in a polarizing environment, actually, because that means it doesn't tend to swing like a pendulum one way or the other in a big way. It goes, a little like that. Which is why I tell my students whenever we have a review class that it's always good to dance when you're preparing for a law exam. And I stand still and I tell them I'm dancing because, that's how much lawyers typically move. Anyway, but the idea is that you're less, you get less polarized in a judicial system that moves like that. Now, the bigger concern for the judicial system is if the judges become very strongly polarized one way or the other, right? And we have seen something of an increase in that, although not as much as we would see in politics, because judges are not beyond their appointment are typically not elected. They're elected in some states, but at the federal level, they're usually not elected, they're appointed. So that has a moderating influence on them as they get in there. And more generally, there are a handful of issues that typically create or tend to exacerbate the polarization you see. Social issues tend to do that. Significant economic issues tend to do that. Issues related to war tend to do that, or to human violence tend to do that. But most of the cases the courts get are usually not like that. I tell people this a lot, but they often don't believe me. But the 90-some cases that get to the Supreme Court of the US, there are probably not more than 10 of them that touch upon very polarizing topics. That's not to say they're not important, it's just the topics are not necessarily polarizing. For example, how much can you rely on arbitration agreements? That to me, that seems interesting, but it's not something that's going to excite commentary on MSNBC or on Fox or any other channel. No one will probably care, except the litigants and people in the business community. They'll care a lot. Other cases you're going to have will deal with matters that seem like angels dancing on the head of a pin, doctrines of international law and things like that. A lot of what we consider fundamental to the US system has been kind of settled. How the states interact with the federal government, that's kind of generally understood. Things like that. So although polarization is bad for the health of the polity, for the legal system, I think the polarizing effects get a little muted just because of the way the legal system works. Having said that, I think it's often helpful if people get the opportunity to actually see, like spend a couple of days in court watching how cases are run, you'll immediately notice the sort of the moderating influence. You might even see the humor in it at times, but it doesn't work. Very few cases, very few judges will entertain a dramatic argument and polarizing kinds of things. You see that more on television than you do anywhere else. In some respects, the legal system allows things to cool down, which seems counterintuitive because people go to court to argue a matter or fight a case. They even say they're fighting a case. But it's, you get into it if you see litigation, yeah, it tends to slow things down, actually. And if anything, in the US, litigation encourages the parties to settle out of court. That is, don't be in court. So
Yeah, I think we'll go one by one. But Billy, yeah. Professor, my name is Billy Roselle. I'm a sophomore. We saw over the summer a Supreme
Nice to
Court
meet you.
case on the immunity, presidential immunity. So I don't know if you could just touch on that,
Yes.
how that changed the law, essentially.
So the presidential immunities is a pretty intricate area, but essentially what it's doing is it's saying that the president's range of immunity is a little broader than the government was claiming it might be. The background, of course, is to what extent are President Trump's actions during his first term subject to being reviewed by the courts, and to what extent would they be protected by presidential immunity? Presidential immunity is the US version of saying that you can't sue a sitting head of state, typically speaking, and you can't sue a sitting head of state for activities done while they were a head of state unless they violate international laws on certain very big topics like genocide or something like that. In essence, the decision was essentially saying the president can claim a little broader immunity than might have been thought by the government bringing the case. Will that mean anything for President-elect Trump? Well, since he's going to be a sitting head of state again in about a month and a half or 2 months now, it seems unlikely that it will matter much for the next 4 years, because it's highly unlikely that a criminal case will proceed against the sitting president of the United States while he's president. It may be held in abeyance, and then once his term is over, they might try to reinstate it, but that's a ways off. The broader trend that's happening, though, and this is something that people who study constitutional law more than I do, and especially presidential immunity, will tell you, is that generally speaking, over the last 40 years, there has been a trend in the US Supreme Court to increase the powers of the president. If you go back to the founding, the federal government was supposedly going to be relatively limited in its powers, and the president would be subject to a series of checks and balances and things like that. Over time, I think, of course, the federal government has become bigger. Society has changed, so the needs of people in society also change, and the state has reflected that. But certainly over the last 40 years, I think the extent of the president's powers to do things have increased quite a bit. Part of that has been just by, courts incrementally increasing it a little bit here and there. Others have involved actual legislation. So some of you might have been following the Ukraine-Russia war, right? Some of you may know that the US government has imposed sanctions on any business entities that are doing business with listed businesses in Russia, as well as listed individuals. So for example, if you were to sell stuff to Vladimir Putin, the US government would blacklist you from doing business with it and impose sanctions on you. That law that allows those sorts of sanctions, the way it works is the US president sits down and says, who should we impose sanctions on? And does. That's it. There isn't like a committee or something, or a regulator that sits there and says, let's think through how we should structure this and that. No. The US president issues an order, and sanctions are imposed. It's unusual to see that kind of power sort of located in the president so easily. Normally, you need to have an underlying law that says this is how things work. but this law was designed to be kind of a quasi-emergency measure. We see other sorts of things that are like that. The increasing use of executive orders, all of those things are really reflecting the increasing power of the president. And presidential immunity is the flip side of that, which is when you reduce the when you increase the scope of presidential immunity, you are essentially increasing the power of the president, because you're reducing how accountable they're going to be by enhancing their immunity. And that, of course, can have its own effects outside of the personal issues. That does mean that the ability to hold the president accountable for certain things gets limited, at least in the legal system. You may be able to hold them accountable in the political dynamic by voting them out of office, by impeaching them. But legally, going to court and blocking or doing something like that, that becomes harder. But that's been a general trend in the courts. That's not unique to President Trump. We've seen that over the last 40 to 45 years. It's just increasing power being sort of located within the presidency, which makes those elections really important.
Yeah.
Go ahead, yes.
Okay, so I'm Nico, I'm a junior, and I was just wondering your thoughts on the proposed Department of Government Efficiency and its legality of a lot of the things that they've been saying about
Yeah.
interactions with organizations or departments like the IRS, the CIA, and Department of Education, which are very established.
So the Department of Government Efficiency, as I mentioned, is not a real thing yet, because to set up a government department, you actually need to have a legislation that enacts it, which would mean Congress would have to pass a law saying, here's a new department. I'm not quite sure President-elect Trump is going to push that. It would be ironic in a way to say, I'm going to spend the effort and time to create a new department in order to get rid of departments. There's a certain inconsistency in that logic. But my sense is that what is more likely is he will have Elon Musk and Vivek Ramaswamy and others as close advisors. And what they suggest they should cut or trim down, he's then going to send down, if that requires legislation, he'll probably propose legislation to do it. If it doesn't require legislation, if he can do it, he might just do it himself. And there may be areas where it's unclear who can do it, and that might have to be resolved by the courts. What are they likely to target? So it seems quite clear, if one goes on President-elect Trump's stump speeches, he wants to reduce the Department of Education. That seems like one area he's likely to want to trim back on. It seems also likely that he will trim back on certain climate change regulation. He may re-regulate too, who knows? That is, change the existing regulation to something he considers better. He's likely to change some banking regulation, I think. I can imagine them changing tax. Tax rules sometimes require additional government oversight, the way it's set up in the US. You sometimes have to do it through Congress. He might also, I think those are some areas, tax, I think for sure, but he will probably not need to cut regulations as much as just pass new law to, flatten some of the existing rules. The tax code is very large. This isn't, I'm not in my office right now. This is just a fake background. But when I am in my office, on one side of it is the tax code, and it runs for a couple of shelves. It's pretty long. I don't teach tax, and I still have it in my room. So it's not out of interest, I can assure you. But it's there. My sense is that you will potentially see something in the immigration space. I don't know if legislation is hard in that area for a variety of political reasons, but I think executive orders and changes in regulation, those are more likely there, and you might see some of that. My impression, based on at least both his stump speeches, but also what I've heard from people in DC, is they plan to hit the ground running. I mean, they don't intend this to be a slow start, from what I've heard. So you can expect a lot. I think immigration, education, energy policy, crypto, finance, those strike me as the ones that are going to get the first rounds of things.
We can, with respect to time, we have time for one last question. One of us, yeah.
My name is Inan Shahada, and I'm a freshman. and this is kind of like unrelated. I had a question about like, does like understanding psychology or having like persuasive skills like aid you in becoming an effective lawyer, or is it more of just like the books and like understanding the policies?
I think being good at anything makes you a good lawyer. The reason for that is that law is so broad and so large and sort of wide-ranging that whatever you're really good in, you can find some area of law where that's highly valued. So, for example, if you're really good at science, uh, a great area of law for you to go into is intellectual property, because if you're going to be advising people about patents and copyright and software, it helps to have a little understanding of it, right? If you, for example, were going to be thinking about where would psychology be useful in law, well, for example, psychology could be very useful in thinking about how to regulate fraud. When I teach white collar crime, a big chunk of white collar crime is fraud, and psychology concerns are very, very paramount there. If you're good in economics, a lot of business regulation benefits from understanding a little bit about economics. If you're very good in history, that tends to be highly correlated with understanding constitutional law as well as property, because most people don't realize this. Our property system is basically the English system with some adjustments here and there. If you are very good in understanding social dynamics, you will be very good in understanding legislative legislation and regulation laws, as well as probably family law, as well as trust and wills and estates. Most people don't realize that uh, your generation, probably your generation, the one 10 years older than you, are on the precipice of receiving the largest transfer of wealth in U.S. history through inheritance and wills and trusts. That makes being a trust and wills attorney incredibly valuable. Any area that you're good in, uh, you can sort of translate to having a very successful career in law. The reason I stress being good in something is law is a competitive field, but it's also a field in which if you have a passion for something, if you enjoy something, you'll really excel in it, because it's one of those things that can take time, but if you enjoy it, it doesn't feel like time. It feels like fun. That's what I tell people when I'm playing tennis. I don't notice how long I'm out on the court because I just like it. Same when I'm doing various areas of law, I don't notice how long it takes because it's fun. I kind of enjoy it. I enjoy, white collar crime in particular. I'm doing litigation a fair amount, so you're on your feet and talking. That can be fun. I don't particularly like hearing the sound of my own voice, but it's still fun getting up there and being involved in an intellectual discussion, which is kind of fun. So yeah, anything you're really good at, you feel interested in, you can find one or more areas of law that would be significantly benefited by that. So I don't think there's a particular path to being a lawyer. I've met doctors who become lawyers and do very well too. So
Yeah.
I was just wondering, in what ways do you think efficiency should be prioritized over regulation or vice versa?
that's an excellent question. It all sort of depends on what the goal of the regulation is. So sometimes regulation is there to stop people from doing things because when you slow them down, people sometimes make better decisions. So I tell my kids this all the time, that if you get angry about something, right, the best thing you can do, wait 5 minutes. Because generally speaking, anger will dissipate within 5 minutes. And that's remarkably sage advice at times. But nonetheless, the idea is that efficiency is great, but you need to understand if the area of regulation you're working in is designed to be efficient or something else, or efficiency and something. So I'll give you an example. Pharmaceuticals, right? They're approved through something called the Food and Drug Administration of the United States. They're the folks who approved the COVID vaccine, for example. Now you might say, how long does it typically take for a pharmaceutical to get approved by the Food and Drug Administration? About 6 years. Like 6 years. That's a ridiculously large period of time, right? They did COVID very fast. Like, I know it might have seemed slow to everybody else, but it was super fast by their typical standards, 5 to 6 years. Like, why do they need 5 to 6 years? That's so inefficient. Indeed, many other countries take 3 years. which also might seem long. Why is that? Because what they do is before they unleash a pharmaceutical on the entire population, they want to do safety testing. Safety testing requires them to go out and have people who are willing to take clinical trials, try the drug, then see the effects. You're not going to look for the effect the very next day. You're going to look for the effect over some period of time, right? 6 months, 3 months. And then you may want to run multiple studies because who knows, you targeted one group of people in New England. Maybe they have features that people in California don't. So then you need to do multiple tests. Over time, over 3-4 years, you have enough tests that now the FDA is willing to take a call on your pharmaceutical. Is that efficient? Well, not terribly, but efficiency isn't the point. The point is they want to be super sure that this is not going to cause large scale damage. Having said that, a lot of the rules that people are targeting, I think, have often been thought to be rules that are vague and rules that leave a lot of discretion to government agents, and then rules that sometimes are confusing. So in the area I often work in white collar, if you have 500,000 federal regulatory offenses, there's a chance that some of them may not be written that well. You know, a lot of people tell me that aren't lawyers good writers? I'm like, no, good writers are good writers. Lawyers are just lawyers. You know, they're not the same thing. Lawyers know how to write legalese. If you've ever read a legal document, you'll know that is the farthest thing from good English. You know, it is not a substitute for reading War and Peace. It may induce you to want to go to war, but it's not a substitute for it. It's just it's a language that lawyers write and work in. So as a result, I wouldn't necessarily think that would make a huge, you know, amount of difference one way or the other.
Great. And with that, I think, yeah. So, Dr. Randolph.
Professor Khanna, thank you so much for zooming in with us today, for sharing your time and your expertise. I'm Mark Randolph, and I'm the guy who sits around in the back and enjoys watching these guys think and interact with you. But thank you so much. I think you might have done a great job of inspiring the next generation of lawyers, which is a good thing. My daughter's a lawyer, so I think of that as a good thing.
Well,
so
excellent.
Thank you so much.
Excellent. You're obviously an excellent father. So
well, she's much better off than I am, I think. So that's all good. I'm glad that someone's protecting our legal system out there besides me. So thank you, Ajay.
Yeah, thank you, Dr. Rao. Thank you so much, Professor Khanna, for being here today.
My pleasure. Thank you for inviting me. I appreciate it. And thank you for all your questions. Feel free to reach out if you have if there are other things that interest you, if you're interested in learning more about law.
Definitely. Thank you for coming and speaking to us today, Professor Khanna.
Take care.
Thank you. Thank you.
Thank you.